Carried out.
Mr. Commissioner, it's Chris Harvey for the Area G Trollers and the United Fishermen and Allied Workers Union. Yes. Mr. Eisvik wishes to say something.
Mr. Commissioner, very quickly, that last tab should have been tab 69. I'm sorry, not 66, 69. Thank you.
Mr. Commissioner, the last document which Mr. Eisvik referred to, I believe, was tab 45. I think what he meant to refer to, he's now saying is tab 69. So I'm going to suggest we just replace the last exhibit, remove what was accidentally entered, and replace it with Mr. Eisvik's document number 69.
Thank you.
Mr. Lund, could we have Exhibit GG up? It's the Nickel case. Dr. Harris, you had, in earlier testimony, you had something to say about what you took the intent of Governor Douglas to be with respect to Indian fishing rights. At paragraph 29 of this Nickel case, there's an excerpt from the dispatch from Governor Douglas to the Duke of Newcastle, which in Mr. East referred you to. You quote from part of this excerpt in your book, but not the final part of it. So I would like to read all of it from the middle, where it refers to fisheries. It says, and they might freely exercise and enjoy the rights of fishing, fishing the lakes and rivers, and of hunting over all unoccupied Crown lands in the colony, and that on their becoming registered free miners, they might dig and search for gold, and to hold mining claims in the same terms precisely as other miners. In short, I strove to make them conscious that they were recognized members of the Commonwealth. Now, that last part serves to clarify the intent of Governor Douglas, does it not? In other words, he was ensuring that the Aboriginal inhabitants had the same rights as other members of what he refers to as the Commonwealth, other members of the body politic, and no lesser rights, but no greater rights either. Is that not the true meaning of that Governor Douglas was seeking to establish?
I think it's fair to say that that Governor Douglas understood Aboriginal peoples as subjects of the Crown, and that they had no lesser rights than other subjects. It's interesting that he refers, in the context of mining, that Aboriginal peoples would have precisely the same rights as other miners, but doesn't say that in the context of hunting and fishing. And so there is, I think, the possibility that he understood them to have certainly no lesser rights and quite conceivably greater rights than other subjects, but they were all equally subjects. Not all subjects have the same rights, however.
But so you don't accept that the proper interpretation of this long sentence is that they are recognized members of the Commonwealth along with everyone else with the same rights?
Certainly they're recognized members of the Commonwealth. They're recognized as subjects of the Crown. It doesn't indicate that they have the same rights.
All right. Well, this is then in the next paragraph, paragraph 30, the Supreme Court of Canada says this, it's Mr. Justice Corey's judgment. An even earlier example of the same concept is expressed in a letter dated April 16th, 1845 from W.H. Draper, Attorney General of the Province of Canada, etc. The Attorney General wrote, so this is the Attorney General's legal opinion. Sir, in reply to your reference of the 10th February last, calling for my opinion whether a fishery in the waters of Lake Huron around and adjacent to certain islands which are within the British territory but have not been formally ceded to the Crown by the Indians is to be considered the property of the Crown or of these Indians. I have the honor to report my opinion that the right to fish in public navigable waters in Her Majesty's dominions is a common public right, not a regal franchise, and I do not understand any claim the Indians can have to its exclusive enjoyment. I think you do not agree that that is the same concept that Governor Douglas was conveying, or do you?
No, I don't agree. So this
All right.
this document was created in the context of another colony of the of Canada West, and in Canada West, as I mentioned earlier, there were a line of cases which indicated that the public right to fish applied to navigable, meaning navigable waters, which was different from the law in England, which was navigable meaning
Yes.
tidal. And it was that latter that applied in British Columbia, not the former.
All right. Well, this case speaks for itself. It is a case of the Supreme Court of Canada. You are a professor of law at UBC. That's correct, is it not?
I am, but the case isn't making the point that this document is making.
Well, the case determines that in British Columbia, navigable waters that are navigable in fact, such as the waters at Morristown in this case, are waters in which a public right exists. Do you not accept that?
Can you point me to the provision of the paragraph where the court says that?
No, I think I'll leave it in my interest of time. That's calling for a legal analysis and a legal interpretation, but I'll leave that for final argument. Dr. Harris, I wanted to ask you this, whether in your historical studies you've been able to determine any estimate of the harvest in pre-contact times in the Fraser River system by, of course, Aboriginal persons. I've heard the number 40 million mentioned. I can't remember where I've heard that, but do you have any number at all that you could put on the pre-contact harvest?
So here I rely on the work of anthropologists and others who've studied this, and I don't think that there is any definitive figure that anyone can put on the extent of the harvest. The harvest would have depended on the size of the population, and even that figure, there are widely divergent estimates of how many people lived in this territory prior to contact, prior to the exotic diseases that decimated the population here. So there's great uncertainty about the population levels, and as a result, there's considerable uncertainty about the extent of the harvest. That said, it's clear that from those sources that along the Fraser, sockeye were the principal source of sustenance and wealth, and that the harvest was very extensive. I would hesitate to put any number.
Yes.
And it's something that I would rely on as the secondary literature for.
All right. The harvest was very extensive, and then also what's called in modern terminology total allowable or total mortality was even greater, was it not? Because in a lot of areas, weirs or barricades were used as a traditional means of fishing, and those effectively blocked the passage of a large number of salmon, which, although not harvested, were effectively killed.
It's certainly true that weirs, fish weirs, were one of the forms of fishing technology that Aboriginal people used. It's also clear, though, that on some rivers, take the Cowichan River as an example, as many as 15 to 20 weirs might have been used in any one season, which suggests a fairly comprehensive understanding of the life cycle and of fisheries management. That
Yeah.
if any one weir could have blocked the fish, then one has a problem. But if 15 or 20 weirs are operating, it suggests that fish are being allowed through and that there's an understanding that fish need to be allowed through.
these weirs are quite often wickerwork kind of fences. There's a photograph of one on the cover of your book, Fish, Law, and Colonialism, marked Exhibit 1137.
That was a demonstration weir that was built in the 1970s.
Oh, I see. But the ones we get from the records are described as, well, let me just look at one of the records. This is tab 59 in, I think, Mr. Eidsvik's collection of documents. If we could have that up, Mr. This is, if we could just look at the second paragraph, this relates, I believe, to the Stewart River barricades. The letter, which is for the Superintendent of Fisheries, dated 1910, reads, "The great objection, as you are no doubt aware, to barricading by the Indians is not only are all the fish prevented from ascending the river during the time that the Indians are capturing them in quantities to suit their own needs, but in nearly every instance, the Indians carelessly leave the barricades after their fishing is completed, and as a consequence, salmon during the whole season are prevented from getting beyond it in any numbers." That's a fairly common report that you get in these early records, is it not?
I would agree that fish weirs had the potential to block all of the salmon returning to a river. And I would agree that the Department of Fisheries was very concerned about fish weirs.
Yes.
But that concern arose in a context where the Department of Fisheries was doing everything it could to protect the industrial commercial fishery at the mouths of the rivers. And so this concern about fish weirs was not emerging in a vacuum. It was emerging in the context of a particular question of allocation about who should have access to the fish.
Well, I'm sorry. The reading that I take from this document is that they're concerned about the fish, the future of the fish, and preventing the extermination of the fish. Is that not the interpretation you put on it?
It is. It certainly, and as again, right, fish weirs had the potential to be a devastating technology, and it's certainly the case that fisheries was concerned. But what I'm providing is the context for that concern, and the context for the concern was a question of for whom are the fish to be conserved. Yes. And fisheries, the Department of Fisheries' particular concern was for the industrial commercial fishery at the mouths of the Fraser or the Skeena rivers.
Well, they were concerned also for the well-being of the Aboriginal inhabitants, weren't they? In other words, that they could continue to obtain their food.
Their concern for the Aboriginal well-being is much less evident in the historical record.
Well, let's just look at this document, for example, page, fourth page in. It's marked 601 in the upper right-hand corner. The upper paragraph, the latter part of the upper paragraph, will start reading about 8 lines from the bottom. If these are not allowed, or let's see, it talks about the etc. And if these are not allowed to spawn, the extermination of the salmon fishery must necessarily be only a matter of time, and therefore the method is clearly not in the permanent interest of the Indians themselves, as the result will be that in the course of time they will have to find some other means of obtaining supplies of food. Well, the document speaks for itself. I wonder if we could have that marked, please.
What exactly is the document, Mr. Harvey?
It's a document. It's a letter containing a memorandum relating to barricading the Stewart and Fraser rivers by the Stewart Lake, Fraser Lake, and Stony Creek Indian bands. Yeah, I'm now encroaching on Mr. Lowe's time, but the point is just this point, Dr. Harris. The Aboriginal people arrived in this part of the world around about the same time as the salmon arrived after the last ice age, I think. Is that general terms correct?
We might be getting to the periphery of Dr. Harris's area of expertise.
This really is history. All right. Well, all right. The point is, and I'll just leave it as a comment, that the salmon have been cropped heavily during pre-contact times.
Certainly, and I think this is clear in my report, sockeye salmon were the principal source of sustenance and wealth for Aboriginal peoples in this part of the world. And yes, the fishery was exploited heavily by them.
Yes. All right.
And for many centuries.
If I could turn next to a document number 93 from the HELTSEC list of documents. This, I think, is a paper that you wrote along with Peter Millard. Is that correct?
That's correct.
Page 99 of this paper is a discussion in the middle of the page. The paragraph beginning, this is page 99, paragraph beginning second, with respect to the modern management of fisheries, the allocation of fish for a particular purpose is a significant complicating factor. A food fishery requires the regulation not just of the act of fishing, but also the uses of the fish caught. Regulating the fisheries themselves is a difficult enough task without also regulating how the fish are used. The second layer of regulation is difficult, intrusive, and a source of considerable antagonism between Aboriginal people and the federal government. Conversely, a lack of enforcement implies a failure of the rule of law and creates resentment within the commercial and sports fisheries, and in some instances within the larger Aboriginal community. That last reference to resentment in some instances within the larger Aboriginal community, that's a reference, I think, to the lack of enforcement of the prohibition of sale, which in some instances has interfered with the ability of the Aboriginal people to get their food fish, food, social, and ceremonial fish. Am I drawing the right inference from that?
What I'm saying here is that it's crucially important to recognize the food fishery and the Indian food fishery as a legal construct and not as a reflection of past Aboriginal practice. It's a construct that's created in the late 19th century and carries through in Canadian law to the present, this category of Indian food fishing. And my argument there with Peter Millard is that it's a problematic characterization because it requires not only the regulation of the catching of fish, but also regulation of the use of fish. And and that yes, this is the regulating a fishery is difficult enough without also having to regulate the use of fish, which is almost an impossibility, or at least requires a level of enforcement that becomes enormously difficult and expensive, and does create resentment both within Aboriginal communities and beyond.
Yes, but my point is, and perhaps you've seen this discussed in the Globe and Mail recently too, that if there's not proper enforcement on the prohibition of sale, those members of Aboriginal communities who actually catch the fish will have an incentive to sell it, and will in fact sell it, rather than distributing it amongst the members of the band.
Perhaps before the witness answers, I wonder again if we're sort of outside this witness's area of expertise and getting into speculation or conjecture.
You're proposing effectively that there be a merger between a right to sell fish and the food, social, ceremonial right, correct?
I think that the simplest allocation is the best, that there should just be an allocation of fish or a recognition of a right to a certain percentage of the total allowable catch and a right to participate in the management of that fishery, but that a bright line is preferable to a right based on the use of fish.
Yes, but what I'm suggesting to you is the Government of Canada has a fiduciary obligation to ensure that whatever regime is in place permits members of Aboriginal communities to obtain their food, social, and ceremonial fish. And the Government of Canada would not be able to deliver that, surely, if your suggestion were adopted and the commercial and the food social right were effectively merged.
I think it's clear that
Okay. Sorry, did you answer the question?
I think it's clear that after Sparrow, Aboriginal people have a right and a priority to a food, social, and ceremonial fishery. This argument was in part a critique of that construct.
Yes. Okay. I've got to sit down now because Mr. Lowes wishes to have 5 minutes of his time, and I've eaten into it.
It's J.K. Lowes for the BC Wildlife Federation and the BC Federation of Drift Fishers. Dr. Harris, you're aware of a decision of the Court of Appeal in Lax Kw'alaams Indian Band in Canada?
Yes.
And Lax Kw'alaams is L-A-X, separate word, K-W-A-L-A-A-M-S. And one of the claims in that case is for rights, fishing rights, based on the reserve creation process.
I'm not entirely certain. I believe so, but I'm not entirely certain of that fact.
Oh, I noticed that you haven't cited that case in your report. Is there any particular reason for that?
I was asked for a report on the history of the regulation of the Aboriginal fishery up to 1982.
Yeah, you cited the Lewis and Nacal cases because of their relevance to the question of implications which are to be drawn or not to be drawn from the reserve creation process. Is that correct?
Yes, I cited them I cited them because I thought their interpretation was incomplete.
You did not cite the Lax Kw'alaams case?
I did not.
And was there some reason for that? Why did you distinguish between that case and the Nacal and Lewis cases?
I responded to the Nacal and the Lewis cases because they are Supreme Court of Canada decisions,
Yes.
unlike Lax Kw'alaams.
Are you aware that Lax Kw'alaams was argued in the Supreme Court of Canada in February?
Yes, or at least I understood that it was being appealed to the Supreme Court of Canada.
I
I
see.
didn't know that it was February.
I see.
I responded to Nacal and Lewis in part because they're Supreme Court decisions, and in part because it's in those two cases where the issue of the connection between reserves and fisheries is squarely before the court. My understanding of Lax Kw'alaams is that the connection between reserves and fisheries is one of a number of arguments, including Aboriginal title, including Aboriginal rights to fish, and that the question of reserves and fisheries is not to the fore in that case. It may be one among a number of arguments, whereas in Nacal and Lewis it was central.
Yes, I agree with you that that you're right, that it's one of a number of arguments, but on that particular argument, the Lax Kw'alaams case is even stronger against your theories than the Nacal case. Isn't that correct?
I don't know.
I have no more questions. I don't have a copy of the decision with me, Mr. Commissioner. I will produce it this afternoon or tomorrow and have the exhibit marked. I can advise you that the case was argued on February the 17th, and we are awaiting judgment.
I believe Mr. Janes is next.
Robert Janes for the Tumuk Treaty Association, part of the Western Coast Salish First Nations group. And I plan to take you a little bit away from the rather engaging discussion you've been having about exclusive fisheries, and I want to talk a bit about the Douglas Treaties, and in particular the commercial fishing aspects of the Douglas Treaties and your approach to interpreting these. And you may recall this morning you were asked certain questions about Governor Douglas's letters and the read of those letters. When you formed your opinions that you stated both in your book, Landing Native Fisheries, and in your opinion, or in your report for this proceeding, excuse me, did you confine yourself to just the letters and the particular words of the treaty when forming your opinion about what the Aboriginal people and Governor Douglas intended?
No.
Could you just discuss with me some of the other factors you considered in arriving at your view that there was a commercial component to the Douglas Treaty fishing rights as recognized in the 1850s?
I guess my conclusion is that the Douglas treaties were negotiated and concluded in a context where Native people were actively involved in a commercial trading relationship with the Hudson's Bay Company. And that my sources for this conclusion lie in the records of the colonial correspondence, in the records of the Hudson's Bay Company, all of which established that, that by the 1830s, salmon was the principal export of the Hudson's Bay Company from this part of the world. It was sending salted barrels of salmon across the Pacific, and that Aboriginal people were the principal catchers and providers of that salmon. And that trade continued through the 1830s, 1840s, 1850s, through when the Douglas Treaties were signed. And so the Douglas Treaties were conducted in a context of an important commercial trading relationship between the signatories. And that it would have been very unlikely that the signatories had understood that they were securing only access to a food fishery, or a food fishery constructed in some narrower terms, when the treaties were negotiated in the context of an important commercial trading relationship.
And I take it when you say important, it's not just important to the Aboriginal people, but also to the Hudson's Bay Company as well.
Salmon were the principal export item. The Hudson's Bay Company had a much more diversified trade west of the Rocky Mountains than it did east of the Rocky Mountains. East, it was focused on furs. Here are a great many things, but principal among them was salmon. And native caught salmon. The Hudson's Bay Company tried for a time to have its own employees catch salmon, and that experiment lasted for a very brief window, and Hudson's Bay went back to purchasing the fish from Aboriginal traders.
In your looking at this background, did you see Douglas in any of his correspondence or in his dealings with the legislature, his dealings with the Aboriginal people, making a distinction between food fisheries and commercial fisheries in any way?
No. There's no sense that the fishery was limited to a food fishery. And again, in the context of a thriving commercial relationship, it would have been very unlikely that such a categorization would have even entered the mind of either the Aboriginal signatories or the Hudson's Bay Company.
And when we're talking about this, we're not just talking at Fort Langley on the Fraser. I take it your comments apply to the area where the Douglas Treaties were signed at Fort Victoria, for example.
That's correct.
Okay. And did you see anything in the correspondence? You know, we've all seen this sentence, may carry on their fisheries as formerly, and the sole occupants of the land and all this stuff. Did you see anywhere where Governor Douglas suggested that they would have to stop their commercial, the Aboriginal people would have to stop their sale of fish or their trade in fish?
No.
And after the Douglas Treaties, do we see Governor Douglas then introduce any concept or restriction on the Aboriginal people, limiting them to a food fishery rather than a commercial fishery?
No.
That's after the Douglas Treaty?
No. So there's some activity by the Hudson's Bay Company to limit the entrance of competitors into the trade of salmon. So they won't sell barrels where the fish are packed in salt and shipped overseas to competitors. But these are immigrants, settler competitors. there's no sense that Hudson's Bay Company is acting to restrict an Aboriginal fishery in any way.
And when do we see this concept of a food fishery as opposed to a commercial fishery start to come into the regulatory framework in dealing with Aboriginal people?
So it appears first in British Columbia in the regulations that are specific to the province. And so the first time where food fishery is mentioned specifically in the regulations dealing with British Columbia is 1888.
So this then appears to be quite a ways after the Douglas Treaties were signed.
Yes.
And in your view, in the work that you've done, what do you attribute the purpose for introducing this concept of the food fishery into regulations and applying it to Aboriginal people?
So the food fishery as a legal construct was a way of containing an Aboriginal presence in the fishery, or perhaps a way of containing claims of Aboriginal rights to the fisheries that might have given rise to access to the fisheries that other people didn't have. The food fishery was a legal construct really intended to confine the Aboriginal fishery, and by that I mean the Aboriginal fishery that was distinct and different from the other fisheries, to a small fragment of prior Aboriginal use of the fishery. So my argument in the paper and in my work is that the food fishery was really performing the same work in the fisheries as the Indian Reserve was on land. The questions of in land of Aboriginal title were being ignored or at least pushed aside. Instead, what was being imposed on British Columbia was a postage stamp Indian Reserve geography that gave Native people toeholds in their traditional territory. In the fishery, the food fishery is playing that same role. It's giving Native people a toehold, providing them some very limited protection for a small fishery, and in effect opening the rest of the fishery up to non-Native use and exploitation. Just as the reserves were providing some limited protection for Aboriginal people on land and opening up the rest of the province to non-Native use and settlement, same in the fishery, same as the food fishery for the fishery.
And as I understand it, even with the food fishery, am I right that the Department of Fisheries and Oceans really tried to approach this even as a permissive matter rather than really respecting it as a right? Is that fair?
Yes, that's fair. The Department of Fisheries understood this as a privilege rather than a right. You see comments that this is bestowed as an act of grace on Aboriginal people. The Department of Fisheries, having constructed this category, then does its utmost to minimize the category. And so from its initial creation, from the creation of an Indian food fishery, the department then adds layers of regulations that allow for the Department of Fisheries to limit the times and the places and the means by which the food fishery can be conducted. And Department of Fisheries' goal, I think it's fair to say, is to eventually to eliminate that food fishery. And you see this in the 1930s, the efforts by the Department of Fisheries to ship commercially produced fish products into the interior so that Aboriginal people can eat these commercially produced products and not catch fish for their food.
And did Aboriginal people react to this with gratitude or indifference?
The program was abandoned very quickly. Aboriginal people simply refused to eat the commercially produced product and continued their fisheries.
And in terms of this general pressure to limit or turn into a permissive fishery, the food fishery, how did the Aboriginal people react to this?
I think it's fair to say that the reaction was presented itself in a number of different ways. The Department of Fisheries would issue permits, food fishing permits, and many Aboriginal people applied for and received those permits. And the process was that the Department of Indian Affairs would provide a list of people who were eligible for a food fishing permit to the Department of Fisheries, who would then issue the permit. Many Aboriginal people fished under a food fishing permit. It's quite clear that many Aboriginal people fished anyway, permit or not. It's also quite clear that in the historical record that many fish caught under this Aboriginal food fishing permit were being sold.
I want to move now to a slightly different topic, and it comes to this question about jurisdiction in a way. But looking at southern Vancouver Island and the people at Songhees and Souk and places like that, is there evidence that they also harvested Fraser River sockeye, and how did they do that?
So the tribes on the south coast of Vancouver Island fished with a technology that's called reef netting, and they fished primarily on islands that are now south of the 49th parallel, or at least in the United States. They would set up a series of reef nets along the southwestern shore of the San Juan Islands. And these reef nets were a fishing technology that involved nets and canoes in paths where salmon frequently were known to migrate. And you'll see in my Inlanding Native Fisheries, I produce a map based on the work of John Lutz that shows those reef net sites, the sites where they were intercepting migrating salmon.
These are the sites on the San Juan Islands, is that right?
These are the sites on the San Juan Islands.
So then if we were to look at the total Aboriginal catch from the Fraser River, we'd have to look beyond just that occurred at the Fraser, at the mouth of the Fraser, but also look at the take on the ocean in the Strait of Juan de Fuca, and I guess presumably in the Georgia Strait as well. Is that fair?
That's correct.
And I take it that in due course they had to leave that fishery because of the border being imposed. But as I understand it, Aboriginal people in southern Vancouver Island continued, at least for some time, to participate in that Fraser River fishery on an interception basis using more modern techniques. Is that fair? Such as boats and gill netting and things like that.
So I don't know the details of the rates or degree of participation by southern Vancouver tribes in the modern fishery, but I have every reason to believe that it did continue in some form.
Thank you very much.
David Robbins for the Cowichan tribes, Chemainus, Halitzum, and Penelakut, pursuant to leave of June 2nd to cross-examine Dr. Harris separately from the Tumuk Treaty Association. Dr. Harris, I don't have much time before lunch, but I wanted to pick up on something Council had asked you about pre-contact harvest levels. In answer to a question to Mr. Harvey, you'd indicated that in that regard you'd relied on secondary sources. And on the very first page of your paper, in the first paragraph, you cite in footnote 2 to a document by Hughes, Gordon Hughes, I believe.
Yes.
It's a 1973 paper, Indian Fisheries Productivity in the Pre-Contact Times in the Pacific Salmon Area. Is this one of the sources you're referring to?
Yes.
Okay. I just would like to have that entered as an exhibit. It's document 20 in the Western Central Coast Salish list of documents.
It's 1,151.
Now, for the remainder of my examination, which if we're stopping at 12:30, we'll continue after lunch, I did want to ask about the portion of your paper, pages 8 to 12, where you're discussing the rapid expansion of the industrial commercial salmon fishery in the last 25 years of the 19th century. You had indicated at page 8 in your paper there's a rapid increase in exploitation, and that in association with that there was a large cluster of canneries were on the stretch of the river from New Westminster to Steveston. Okay, and Steveston, of course, is on the main channel of the river. And over on at the bottom of page 10, you indicated that as the exploitation grew, concerns with sustainability developed. And over on page 11, you're talking about what you referenced earlier, the first limited license regime from 1889 to 1992, directed in part at trying to regulate for sustainability reasons. So You have indicated in your paper that 350 licenses were issued, mostly to the canneries. There was initially 450 independent licenses, and as of 1890, there were 150. And you talk at the bottom of page 11 about 40 of the 150 apparently going to Aboriginal fishers. And then what's of particular interest to me is at the top of page 12 with respect to the Cowichan. You state that when Cowichan fishers applied for independent licenses on the Fraser in 1889 and 1890, fisheries refused on the grounds they were not members of a resident tribe. Now, in footnote 30 there, you have a pair of documents. One is a letter from the Indian agent W.H. Lomas, January 16th, 1892, and the second is a response letter from the fisheries officer, John McNabb, to the Deputy Minister of Department of Marine Fisheries, February 29th, 1862. I do want to get those into evidence, but before I do that, I want to take you to some of your work in your previous publication, Fish Law and Colonialism, because I understand those two documents are in fact a series of 4 documents in the correspondence of 1892. I think that'd be appropriate.
Documents. Now, I wonder, is it convenient for Commission staff and council to return at 12:50? Is that convenient?
Did you mean
I'm sorry,
150, Mr.
I
Commissioner?
apologize.
But we're in your hands if 1250 is the preference.
I meant 1:50. Is that convenient?
Hearing will now recess till 1:50.